Bishop, would you come forward and lead us in an invocation, please?
Thank you. Let us pray. Our Father, which art in heaven, we are truly grateful for the privilege of living in this country and in this community, and we are grateful for those national and local leaders that serve us so well. As we enter into this holiday season, may we have our hearts filled with love for family, friends, and neighbors, and to be filled with charity for those who are less fortunate and needy, for truly it is better to give than to receive. Now, as the affairs of the city business are discussed, we pray that minds will be quickened and hearts softened, that our discussions will be thoughtful, sincere, and with civility, and that decisions rendered this day will be with wisdom and in the best interest of our community. May each of us continue to be good stewards over that which we have been given or over that which we have responsibility. May we strive together to enhance the quality of life in Vero Beach is our prayer in the name of Jesus Christ. Amen.
Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. With that, I'll call the December 2nd, 2014 regular City Council meeting to order. Mrs. Vach, would you call the roll, please?
Mr. Roll?
Here.
Ms. Graves?
Here.
Mrs. Turner?
Here.
Mr. Kramer?
Present.
Mayor Winger?
Here. All right, preliminary matters, agendas, additions, deletions, and adoptions. If it pleases the council, it would look like 4B, 1 and 2, which are matters that our attorney, Chef Wright, is dealing with. We should probably move those forward if it's agreeable with the council during his comments.
Okay.
Is that agreeable?
Yes. I'd just like to say that then you're putting the public comment and Ms. Castle on everything that could be an extensive discussion, and I would suggest that we have it after public comment.
Well, again, it's the pleasure of the council, whatever the council wants.
Anytime we take any action, it's by law we have to allow public comment. So, I mean, it'll be ingrained in the conversation.
No, but I mean the general public comment, if there's anybody.
I think that'd be okay.
I don't see any problem giving public comment before it. That's fine.
Is that fine with you? So, how about, do you want to, well, the consent agenda will only take a minute. So, okay, we'll then if I have a motion to adopt the agenda the way it's printed,
Well, could I make a motion that we
Yes.
put under public comment, we move Ms. Castletine above Mr. Wright? Let her do her presentation?
I'd agree with that. I think
Okay.
that's a good suggestion.
All right. I think we have consensus on that, so we'll do that. We'll reverse those two.
Motion to approve is amended.
Second.
All in favor?
Aye.
Aye. All opposed? It passes 5-0. All right. Who is coming forward? The police department. Oh, Chief Curry, I see you there. I didn't see you in your blue. I'm sorry.
Morning, Mayor and members of the council. David Curry, Police Chief. As you know, the Treasure Coast offers crisis intervention training, and our agency since 2008, we've sent over 45 officers to this training. It's a 40-hour training session, and it helps our officers learn to deal with situations involving the mentally ill individuals that we come in contact with from time to time, to include substance abuse. And we've again sent 45 or so officers since 2008. Sergeant Huddy, who's been with us since 2000 and was promoted to sergeant in 2011, is one of those graduates as well. It's a Treasure Coast effort. St. Lucie, Indian River County, Martin County, and Okeechobee sends their deputies and their officers and correctional people, even dispatchers, and that's what we'd like to do as well in the future, to this training in an effort to assist and better understand some of the individuals that we deal with in the situations that we have to deal with as well with mentally ill individuals. So on November 6th, just about a little less than a month ago, Sergeant Huddy was recognized as the Treasure Coast Crisis Intervention Team Officer of the Year. And again, that is a 4-county area, and that was in Port St. Lucie. We thought it would be nice for you to know that and to share that with you and the viewing audience and the members that are here as well today, and tell you a little bit about why he was chosen as the Crisis Intervention Officer of the Year. It was just about a year ago, November 26, 2 days before Thanksgiving, when one of our own city residents, 22-year-old male, was on the Barber Bridge. And a passerby called us, and he saw the individual. It looked like he was leaning over the bridge, possibly wanting to jump. So the individual called us. We started our units that way. Sergeant Huddy was the supervisor that day. This individual's mother called thereafter and said that her son had called her and said he wanted to end his life by jumping off the bridge. So again, we're en route. Sergeant Huddy and the officers involved that day, essentially, when we got there, it was on the westbound traffic of the Barber Bridge. The individual was at the top of the bridge. We shut down the traffic. Sergeant Huddy utilized all his members and were able to distract the individual and get him down from jumping. And he was a very important part of that day as a supervisor and as a person that has been trained in CIT. So that was submitted by our Lieutenant Matt Harrelson, and he was chosen again and awarded that on November 6th. But I thought it was very important to share that with you this morning. So I just want to again recognize Sergeant Phil Huddy for being the Treasure Coast Crisis Intervention Team Officer of the Year this morning.
Thank you. Thanks, Steve.
You're welcome.
Thank you very much.
We're proud of it.
Just for the mayor and council, also, I think it's a lot of dedication of our officers because the training such as this really are more diversified, and it shows the differences of what police departments are called upon to do in today's world as opposed to when it was just law enforcement such as traffic stops. But it's a very diversified field. The careers are very challenging. Hopefully we are providing the training that is necessary in order to address the needs of our community. The other thing is, and while the chief is standing there, he is also involved in many of the regional programs in which gives us insight into how these activities work and the training that is available for our officers. And appreciate both of y'all and what you do.
And I just wanted to take this opportunity to thank the chief and all your work in trying to lobby for the mental health court. I know, mental illness and dealing with these issues poses just an incredible challenge. And I really appreciate your attention and efforts.
Part of that effort is to divert the ones that need to be diverted. And as you may know as well, we went before the county commission recently. And when I say we, Sheriff Lohr and Judge Cox, Cynthia Cox, and a number of Chief Morris, Chief Tewksbury, as far as the law enforcement community here in Indian River County, but a number of service providers as well. And St. Lucie County has been very successful in having drug court. We're in the same circuit, and now hopefully we will have drug court come the first of the year. And again, this will enable us to, if we arrest, say, an individual homeless or mentally ill for a misdemeanor, it may be a trespassing charge or an open container or things like that. Lesser misdemeanors, they go to jail. There's a case manager at the jail. They divert them into referral services as opposed to the criminal avenue, if you will. And the key to that, and it's been the health community here in Indian River County, we should be very proud of as well, because that's part of the collaborative. And the key is just that, the services. If we don't have services to divert these people to, then the court won't work. So we have the doctors on board that are coming on board, different services, and that's the key to getting these people help as well. So hopefully you'll see that. We'll see that around the first of the year. Mental health court here in Indian River County. Thanks again.
And congratulations.
Thanks for bringing this to our attention, and Sergeant Huddy, great job.
Thank you. Happy holidays.
Mrs. Castletine, would you like to come forward and give us an update on the countywide economic development positioning analysis? Those are a lot of words.
Yes, it is. Good morning, Council, Mr. Mayor. Thank you so much for allowing me a few minutes on your agenda, and I will keep this very brief. I know you have a big morning. For the record, my name is Helene Castletine. I serve as the Economic Development Director for the Indian River County Chamber of Commerce, 1216 21st Street, Vero Beach. And I wanted to take this opportunity to update you on where we are with this positioning analysis. As you might recall, it was about a year and a half ago now is when we began considering doing such an analysis, and this was at the recommendation of the county's Economic Development Council, of which your Vice Mayor, Councilman Kramer, serves. And we have partnered now with the Board of County Commissioners to undertake a positioning analysis, hiring a consulting firm, 80 Voltage, to take a look at Indian River County and its municipalities to see where we are as far as business recruitment, business retention, and expansion. What do people think of us when they consider Indian River County or Vero Beach as a business location, both within our county and those who are outside our county? The consultants were in town last summer in July and conducted a number of interviews, small group discussions. In all, there were about 120, perhaps 150 interviews done with our local stakeholders, and that included elected officials, government officials, business leaders, workforce development, education representatives. It covered the gamut. And the report so far is actually available to review online, both on the county's website and our Chamber of Commerce website. We're about 2/3 of the way through with this analysis, and that's why I thought this is a good time to give you an update of what's up there. There are different sections that cover different components of this analysis. The first was all the comments that were gathered. Of course, people's identities were not revealed, but all the comments are on there, and it kind of gives you a good perspective of what our stakeholders' thoughts are as it comes to Indian River County and the cities as to the business environment that we have. Some are very different and kind of conflict with one another, but it depends on their perspective. Another section that is up on the website now is there was a site and building assessment done when the consultants were in town. I took them to 12 different locations throughout the county to take a look at both undeveloped sites as well as vacant buildings so they could get a feel of what we have to offer those potential businesses that are considering locations for expansion or relocation. So there's an assessment of that study. More recently, there was an asset analysis done and a target industry analysis done. It's not real comprehensive. A target industry analysis can be a study unto itself. So this was just kind of a fast glance of what we have as far as our target industries and a recommendation that perhaps we might want to narrow that list down just a bit. I will tell you that the report, if you are to take a look at it, I would caution you if you're thinking about printing it out. Right now it's 97 pages.
Wow.
So you might want to save a tree or two. But it is available on the county's website on their community development homepage, IRCC, Indian River County Community Development.com, IRCCD.com. But it's also available on the Chamber website on the Economic Development homepage. Our website address is IndianRiverChamber.com, and when you click on the Economic Development page or tab, it's there on the home page. So I think it's a really interesting read, and to kind of get you up to speed, that I think it would behoove you to take a look at it, because you guys certainly are our stakeholders, as are all the municipalities in Indian River County. I'll also invite you to mark your calendars. Thursday morning, January 8th, we'll be having another one of those community leaders summits like we did last summer. And it'll be held at the Sebastian City Council chambers. It starts at 8:30 in the morning. It is a public meeting. We would encourage all of you to attend, as well as our residents. A draft of the full report will be discussed. Again, time for input, time for comments. the timeline is that we're looking to finish up this project in March. And once it is finished, the next step is to take a look, to see if our marketing materials, our collateral, our target industries, target geographies are what they need to be. And we may need to make some changes based on those recommendations. So just to kind of get you up to speed on where we are and invite you to this January 8th event. I hope you can all attend. And again, it's at the Sebastian City Council Chambers, 8:30 on Thursday, January 8th. It is open to the public. And I'm happy to answer any questions if you have any.
Who has questions for Mrs. Castletine? No questions.
All right.
Thank you.
Well, thank
you very much for
appreciate it.
taking the
Thank
time
you.
to come forward.
Thank you.
Mr. Wright, would you come forward? You're going to update us on utility litigation, and I guess we'll get into the resolutions a little bit later on as a separate issue.
Yes, sir. Good morning, Mr. Mayor, council members, citizens. Glad to be here again. Thank you. There's sort of a lot of things to cover and some news. I'll start with the events of last week. As you know, on Tuesday, the 25th of November, the Florida Public Service Commission was scheduled and had on its agenda to take up the county's petition for declaratory statement. Apparently, the events of Monday night and Tuesday morning went something like this. The county reconsidered what they were going to do with their petition, and on Tuesday morning, they communicated to the commission staff that they wanted to present 4 somewhat different questions to the commission for its Public Service Commission, that is, for its consideration instead of the 14 questions that they had articulated at some length in their petition for declaratory statement. The staff attorney with whom I spoke said, "No, you really can't do that. That's amending your petition, and we will have to start over with a new 90-day clock under the statute, and we'll have to renotice it," and so on. And there was apparently some scurrying around that ultimately led to the county's request that the item be deferred, which was subsequently documented in a letter later that day. At the time, this was in the lobby of the PSC afterwards, the county's utility specialist attorney, Floyd Self, said that they would be filing a revised petition with a couple of questions on Monday, December 1, that's yesterday, and he also recited that fact in the letter that was sent to the commission later on Tuesday the 25th. I will tell you, as of a few minutes ago, I checked using my phone the PSC's website, and they have not filed a new petition for declaratory statement yet. Procedurally, the bottom line is that will start a new clock. If the declaratory statement statute, Section 120.565 Florida statutes, which is part of the State Administrative Procedures Act, provides that an agency presented with a petition must rule on it or explain why they're not going to grant it or issue it in the negative, whatever, within 90 days. The Commission, Florida Public Service Commission, has agenda conferences on February 3, and then they don't have another one until March 3. So allowing for time to get the order out, if they file their revised petition today, realistically the Commission would have to vote on it on February 3rd in order to be able to get their order out by whatever 90 days from today is, which is approximately March 2nd or March 3rd. If they wait a few more days, that might push it past the March 3rd agenda, and we'll just see. My expectation is that whatever questions they ask will be similar to what they have asked. We will respond accordingly. My hope is that it will not require significant additional research, but rather reworking the extensive pleading that we filed in response to their first petition. Any questions about that one?
Are they required to refile? It's just a procedural question.
No, sir. It's strictly at their option. They have styled it. They have styled what they say they're going to do as filing an amended petition. But in legal substantive terms, this is essentially a voluntary withdrawal of the petition they filed, which they intend to replace with a new one. We could argue about the semantics of that, but it's not important. They can file a new petition or not. That's completely up to them.
I guess we have no questions on that. Move on to...
Okay. The town litigation, the lawsuit per se, remains in abatement by order of the court, and that's what happens when one governmental entity sues another governmental entity. That invokes the mandatory procedures of the Florida Governmental Conflict Dispute Resolution Act, and those require abatement. So technically that case is actually closed. It's in abatement. And we have gone through the first two phases of the conflict resolution process. Those are the conflict assessment meeting or meetings. We had two at staff level, the joint public meeting, which we had in October, and then we are headed toward the mediation, which is to be held on December 17th. From an email exchange yesterday, it looks like the mediation session will be held here. This is an unusual situation and an unusual process, and there was rather extensive email discussion, one conference call had amongst the attorneys involved as to whether the mediation process was or is to be held in the sunshine. The majority view was that it would be held in the sunshine, and so it's going to be wide open public. Some thought there surely will not be private breakout sessions with the mediator, who is Carlos Alvarez, by the way, a very good mediator. I've worked with him, as has Dylan, as has Bruce May. We've worked with him on different matters over the years. He's a very good mediator. But he won't be able to go meet privately with any of us. We might be able to step aside and confer amongst ourselves, something like that. But in terms of any kind of private shuttle diplomacy meetings, as would happen in a normal mediation, that is not going to happen here. I'll just tell you my view on this. I am perfectly happy for this to be completely in the sunshine because we don't have anything to hide. And beyond that, I don't think it will. Go ahead.
A procedural question on the December 17th. Who is attending from each of the three entities?
From the town, it will be Bruce May, Robbie Stabe, the town manager, and the mayor, Brian Barefoot. From the county, it will be Dylan Reingold, the county attorney, Floyd Self, their utility specialist attorney, Joe Baird, the county administrator, and an elected official. I don't think they have identified who that will be, but it will be one of their commission members. From the city, it will be Mr. O'Connor, Mr. Clement, myself, and if one of y'all wants to come, that'd be great.
Well, that puts a question to the council. I mean, none of us can attend without the permission of all of us, and I don't know what you would recommend, and I don't know what others think, so I will say nothing more, but we need to make a decision because we won't have another meeting before December 17th.
No, I'd say certainly the mayor should attend. However, it is an open meeting, and I assume that all members of council can be in the public in attendance.
Yes.
Yes, absolutely.
Yeah.
Is that what Mr. Turner said agreeable with you all?
Yeah, it's fine.
Oh.
Yeah, okay.
Yeah, I'm looking at my city
Hey, Jim?
attorney over here. Just in terms of the possibility of council members conferring amongst themselves.
Yeah, that's the only thing I would caution against because I mean, we can advertise it as a council meeting, and we'll probably need to advertise it in some form. Quite frankly, without an elected official there, I wasn't concerned with advertising because my opinion still is it's confidential and it should have been confidential. But we're not going to dispute that. And as I agree with Chef, we have nothing to hide. So it's just, it really hampers the mediation process. And I don't know how well the mediator will be able to do his job in the public. So,
yeah, my concern is I think it would be great if all of y'all were there. I just don't want there to be a sunshine problem if two members of council were to talk amongst themselves. That is a conversation that has to be in the sunshine and noticed.
Right.
So you might want
certainly we're aware of that.
Having
observed that we cannot have those conversations.
Yeah, I mean we'll advertise it as a public meeting. unless we're going to advertise it as a council meeting specifically, and then even if you had discussions, obviously they'd have to be on the record and where the public could hear it, and it's really not going to be set up that way, I don't believe. So if you do attend, I would just still caution you don't talk amongst yourselves, even though it may be a public meeting.
Yeah, we will advertise as a public meeting. I would recommend that we not advertise as a council meeting, because I don't think you guys want to go into sitting up here and debating. But I think the process is it is an open meeting. It will be advertised as a public meeting, and the public will be encouraged to attend if they choose. And whether you sit up with Wayne and Chef and I makes no difference to us, however you want to do it. Although I'm not really sure how the tables are going to be set this time. And hopefully everybody understands that in this part of the process, what you say can and will be used in the court if necessary as we go into the litigation. So we just need to be careful as to what our comments would be that be recorded.
Mr. Wright, one other thing, and we agreed to do something this coming Friday for the legislative, and I think probably an update on that is part of this whole thing.
Sure. Could I talk a little more about the town's lawsuit before we get to the...
Talk about anything you like. That's what you're here for.
You are the mayor, and I shall do what you ask. But if I could, I'd like to stick with the flow I had with the...
Okay, let's do that.
Continue talking about the lawsuit. If we were somehow able to achieve a mediated resolution on the 17th, that would be great, and we would document that, and everybody would go back to the respective elected bodies, and we'd get it approved. If, on the other hand, the process goes to impasse, then at some point something will happen. I expect something will happen, certainly from everything that the town elected officials and their attorneys have said. They will reinstitute the lawsuit. There's some speculation amongst the utility lawyers in whose circles I run that they may file an amended complaint, or they may simply reactivate the complaint they have. Regardless, at some point after December 17th, we will be back in active litigation with them, and we will see what happens then.
Just as a side note to that, our RFP for a litigator will be on the streets next week, and we'll be searching for someone who has that specialty in litigation.
Okay, I guess that gets the natural flow as you
Thank you.
put it.
Thanks for letting me close the loop on my own thought process. There is a meeting of the legislative delegation this Friday. We're not sure exactly what all is going to be taken up, but the mayor and I submitted, or the city submitted a request to address the delegation, identifying the mayor and myself to talk about any issues related to the city's utility situation that may come up.
All right. Any further comment? We're going to come back to Chef after public comment, after the consent agenda.
As I said, I will do whatever you ask. I did want to talk about the status of our discussions with OUC, but I can do that after.
No, go ahead. Do it now.
And I apologize for the fact you didn't get this memo till yesterday, but I didn't get the information from OUC that's covered in the memo till late Tuesday afternoon, the Tuesday before Thanksgiving. So it was the weekend before I was able to put it all together and write the memorandum. As explained in the memo, and as we all know, Mr. O'Connor and I have been meeting periodically with OUC's senior management since August the 20th was our first meeting. I think we've had 4 or 5 meetings with them, plus I had one additional meeting by myself with them at a time when Jim could not attend. The first series of discussions led to the proposal that was submitted to you all at Council and to the Utilities Commission as well on October 21st. And they made some proposals that they believed that they could take to their board and that would be approved, subject, of course, to their board's approval and subject to our approval. There's a table in this memorandum. It's the first page following the text of the memo that summarizes the provisions of the existing power purchase agreement with OUC that we entered in 2008. And then it's got another column for the October discussion points and the November discussion points. I will call to your attention there's a typo in the header of the October discussion points that should say October 20, not October 25. I think I must have blocked and copied from November 25 over to that column and didn't change the number. But it was October 20th discussion points that we discussed on October 21st. And as you know, they offered us significant pricing discounts in the capacity payments. The term would stay through 2029. We would buy peaking capacity from them. There would be a minimum floor on what we would pay for in any year for capacity of 85 megawatts, which is 8 megawatts lower than the lowest level we've ever taken that I'm aware of, which is 93 megawatts, and between 10 and 15 megawatts lower than what is projected for this year and next year. So it doesn't seem like a strict binding constraint on us, but it does give Orlando Utilities some protection, which is of value to them as part of the value transaction between the parties here.
Excuse me,
Yeah.
just
Sure.
because we're on this this capacity.
Mm-hmm.
In the event that we are unsuccessful with our litigation with Indian River Shores, how many megawatts would we be losing with Indian River Shores that would be involved with this take or pay?
Two things. 9%, 10% of what? 10% of 100. Probably 15 megawatts, 12 or 15 megawatts. But the second point is that I have specifically discussed with my counterpart at OUC, Chris Browder, the general counsel, and that we will have a force majeure type adjustment clause in whatever we do that would allow us to adjust whatever we needed to adjust in the event of judicial or legislative or regulatory action that would cause our ability to purchase the amount we purchase from them to be less.
And no additional cost to us or no financial impact.
Correct.
Correct?
Yeah. Then they understand the realities of our situation, and they're willing to work with us on that.
Thank you.
Yes, ma'am. And beyond that, there in the October 20th set of proposals or discussion points, OUC would have a unilateral option to terminate as early as 2020 with 2 years' notice. They would have an option to buy the city's share of the output of St. Lucie pursuant to a PPA, not pursuant to an assignment. And they would receive the permanent rights to our gas transportation capacity under our contracts with Florida Gas Transmission Company, or FGT. In discussion at the Utilities Commission and in discussion at Council on the 21st of October, some concerns were expressed about some of these things. There was concern that we were still in a 15-year contract, and there was concern about the St. Lucie option and whether we were giving up more value than we should. There was concern about gas contracts and concern about OUC having the unilateral option to terminate early. We took those concerns back to OUC. Mr. O'Connor and I met with them again on Wednesday, November 19th, about 2 weeks ago, and we had frank discussion, and that led to their sending us the new proposals, which are further back, just behind this table in the packet that I received on Tuesday afternoon last, a week ago. And the differences are the no termination option at all, shorter term, just a straight out shorter term, terminating at the end of 2023. So it'd be from today, it'd be a 9-year deal as opposed to a 15-year deal. No St. Lucie option. OUC would get the gas transportation rights, except the city would have the option to reclaim or recall those rights if we so desired, because we need it. That's not an unreasonable ask for them. They say, well, we'll give them back to you if you need it. And their criterion for if we need it is if we build new gas-fired capacity that we own at our power plant site in service by 12/31/2024, we can ask for the gas contracts back, and they'll give us the gas contracts back. And as I said, it's a shorter term, 9 years as opposed to 15. Not surprisingly, as I hypothesized at Council on October 21st, there's less value to OUC, so the base capacity pricing is higher than in the October 20th proposal, but still noticeably less than the capacity pricing in the existing PPA. So that's what's on the table, and further, OUC did confirm to me, in a conversation with Mr. Browder, he confirmed to me that, yes, we, the city, can choose between either of these two options. There are moving parts to each of these variables that we need to consider, and my recommendation is that we undertake to analyze what we think the likely scenarios are and make the best, most informed decision one can make as we will be standing here in January or February whenever we get to this. As Commissioner Gerald Gunter of the Florida PSC, the late Gerald Gunter, said to me one day, he said, "Mr. Wright, is that a projection?" I said, "Yes, sir." "What do you know about projections?" "They're going to be wrong." And the point of that is there are risks inherent in whatever decision we make. If you go with the 9-year contract, there are risks that the market prices in 2024 to 2029 will be higher than what we could get if we took the contract today. If OUC were to take the St. Lucie option, there are risks that might turn out to be a very good deal for them and correspondingly not such a wise decision for us. If they were to take it for the rest of the plant's life, there are risks that it might turn out to be a not such a great decision for them and a lucky event for us. You just don't know. And so all I can say is I think we ought to look at this as hard as we can, cover the waterfront with ranges of what we think the values are, and bring it back to the Utilities Commission and bring it back to you all to make the best decision we can.
Further questions, comments?
I'd say certainly there is a lot of sensitivity and analysis cases to be run, and I appreciate, I guess, you at least outlining a few of those in your memo. I think the next step for us then is to see about how we can go about getting some of these analysis done.
And we'll proceed under that direction with the council. Chef and I will be working with, obviously, folks in our electric department as well to try to come up with the scenarios, possibly those that we have faced in the past, so it'd give us some real-life experience in what we're doing. But we'll proceed down that path, make a presentation to the council, hopefully in the January, February timeframe. The key is we just want to make sure that we address those concerns that were voiced when we went back to OUC, and I think we picked out at least the three major ones. And just to let you know on the gas, even though it appears that we're giving up, the gas pricing, and there's so many complications with FTG that we really would not have any major benefit outside of using it ourselves at a location. So it's not something that has a per site value, but the rest of it is something that we'll have to analyze as to what is the true value to us of St. Lucie Power Nuclear Plant. As an example, we have documents that show that as a negative number, but it also is a risk factor. But we'll bring all that information back to Council for your consideration.
Yeah, if I could just add briefly on the gas contracts. If we have the contracts, we're paying for the capacity at the contract rate, which I think under one contract is 82 cents a million BTU a day, and the other one it's 71 cents or something like that. But we're paying for it. That contract is good to deliver gas to Big Blue. If there are not constraints on the system, it can be redirected to other delivery points. Sometimes there are. Most of the time there are not. But the value is greatest for delivery here. But if we have it, we're paying for it. And if we release it and sell it to somebody else, we can own the maximum price at which we can release it is the 82 cents or the 71 cents. It's not like we can go out and make money. If we have it, we're paying for it, and to the extent we release it, we're ameliorating what we're otherwise paying for. I think that's what Jim was getting at, and I should have covered it when my first remark. So I'll sit back. Question? So I'll sit back down and wait till it's my turn again.
Yes, sir. Yes, sir. Thank you.
Thank you, sir.
Just for information, this was presented to the Utility Commission yesterday as well. So.
All right, we'll open for general public comment, and there will be public comment after each item, of course, on the agenda as we get to it. So is there open public comment? Yes, Mr. Daig, I saw first, and then Mr. Gafanti second.
Good morning, Mr. Mayor. Good morning, City Council. Ken Daig, 1846 21st Avenue. Wanted to bring to your attention a railroad situation. Hopefully you got this email that we sent out on November 20th. I had some questions for the county. They responded back. I got the email December 1. Hopefully you saw the response from the county. I had asked 6 questions. I'll go through those real quick. I did a public records request pertaining to all aboard Florida and the DEIS study and the railroad crossings within the city of Vero Beach. It was addressed to everybody that it needed to be addressed to. I had asked, is Indian River County acting on behalf or including in some representation fashion the city of Vero Beach and rail crossings within the city work order number 10 dated April 16, 2014? If so, please state the action. Number 3, is Indian River County acting on behalf or including some representation fashion the city of Vero Beach within the continuing CDM work orders and or other legal representation pertaining to all aboard Florida and the DEIS as of November 18, 2014? If so, please state the section. Number 5, are there any agreements between the city of Vero Beach and Indian River County pertaining to all aboard Florida, the DEIS, and related issues? If so, please indicate where. Note, it is understood FDOT has surveyed the twin pairs and will comment on this. And I wanted to know when the comment is coming in from the DOT people from our twin pairs. That has not come back. The county responded, and I'll read their response, was very brief. We have received a response from the county on your request. This is from our clerk. And you are told that the county has no records responsive to this request. So basically, we're kind of not included in anything over at the county. If they have meetings as such, I was concerned. I wanted to be at the table to hear what's going on, to either have some council members there. This issue is still moving forward. We still have a number of concerns that need to be addressed within the city limits. I'm still receiving calls from concerned individuals, both city residents and county residents. They want to know, hey, what's going to happen to us? Where's this thing going? What's going on? You know, the questions over and over again. I have informed the folks that do call that our commission has sunsetted. You know, the commission is done. We did quite a bit of work. Hopefully you'll leave the website up. I just wanted to let you know when the DEIS came out and the specialists took a look at the DEIS study, and this is some of their words, it's very deficient. I've gone through the DEIS study in listening to these professionals. They kind of left Vero out. We're not in there. So with that being said, we've had other individuals throughout the community read the DEIS study, and they're asking, well, what about us? One of the things that's come to my attention, I know it's been brought to your attention, is the hospital issue. People want to know how they're going to get there, and that has not been really addressed. With that being said, moving forward, there's still quite a bit of information that's coming down the pike. I would like to be there at the table when the information comes in, especially to the county. There's some other questions that I have that I would like to get addressed. And I would like to work on your behalf, the City Council, to go forward. There's going to be meetings in other cities concerning the DEIS study. They have a lot of the concerns we have where it's deficient, where I can be there, bring information back to you all in the event that you all need to take some type of action to protect your city residents. So I'm willing to do that on your behalf. I just need to know if you would be interested in having me work for you. Obviously, I'm not looking for any money. I do this, out of the, because I do care. So it's up to you guys how you want to move forward.
Are you suggesting kind of like being the ears of the council to kind of gather information to bring it back type of thing? Or
Yes.
I don't have a problem with that.
That would be great. I think that
I don't have a
commend
problem
you
with
for
it
doing
either.
it. Yeah.
And then at different times, I do need to work with staff members where I do public records requests. I like to still have that option. There's still some questions that I would have for our city manager and also for our public works director. So I still like to have a foot in the door as far as working with them. So if I have your blessing on that, I'll just keep
certainly,
moving.
as any member of the public, our staff is always available for
Right.
for questions.
Right.
In the information that you posted, I talked to Sherry yesterday and understand that it will be kept out there to answer your question.
Okay. Thank you very much for your time. Thanks for your help, and I'll be back.
Thank you.
Mr. Gapati.
Yes, my name is Joseph Graffanti, and I live at 441 Holly Road in the city of Vero Beach. I want to say something about Dag. He was an elected official at one time, and he's one of the few that ever came back here and kept involved with the city of Vero Beach directly in the public. I commend him for that. On the other side of the wall is a comment made by your city attorney this morning saying that his preference was to keep negotiations in private. That's exactly why these issues are here today, because you people and your city manager and your city attorney and all the predecessors thereof have conducted meetings in the smoke-free backroom closets and put the public, the taxpayers, at jeopardy. So that's what's going on, and so I just wanted to point that out. This deal that the learned attorney Wright and your city manager have come up with is an affront to the public, and they're unaware of it. What you should be doing is, and it's directing your attorney, because he's not working for the public, he's working for you, the five of you. His interests, and people may complain about what he does. He's doing a great job because he's doing what you people want him to do, and that's to extend the contract with OUC and FMPA and/or FMPA, as pointed out by Councilperson Turner. If you do this, if you go ahead with this and extend the contract with OUC and/or FMPA, you are going to put, as I said before a couple of weeks ago, the city of Vero Beach, the taxpayers, and the residents, the property owners, the taxpayers, the business people, everybody in jeopardy. Because if the county and Indian River Shores prevail, which they might do, and nobody can say that they won't, regardless of what they may think the law is. You never know until a judge says, well, we're not going to do it that way anymore, as in the case of people forced to riding in certain people forced to riding in the back of the bus. That thing was overturned a long time ago, and the courts have overturned certain things. So if that's overturned, the city of Vero Beach is going to be in tremendous financial trouble. And if you extend this contract out, it'll go in perpetuity. That means for those less, well, that means forever. And will be under the thumb of those gangsters over in Orlando or wherever they hide out. The public, your source of power here, again, is always the public's ignorance and indolence. The public doesn't have any idea of what's going on here. And if you extend this out, they're going to suffer down the line. Now, some people talk about the city of Vero Beach going bankrupt. Well, I don't see how that can happen when all you have to do is raise the rates of the electric rates and our power bills and raise our taxes. And this little gimmick that you came up with is going to provide some ephemeral ease, some short-term relief for our power bills. There's $7 million for the first couple of years. And you people, I'm sure, individually and collectively, don't have the ability to analyze the proposal that's before you. You just don't have it. And you don't know. You wouldn't go to somebody who does know about this and who could give you proper guidance. And I'm surely not one of those persons because that's not my field of expertise. So you're getting the city entertaining this, you're getting the public the future in deep weeds, as we used to say. Good day.
Thank you. Further comment from the public? Mr. Moocher, would you like to comment? I saw your hand. Okay, I'm sorry. All right, I'll close public comment. That will move us to the consent agenda. Are there items that would someone like
yes,
to pull?
Yes, I'd like to pull item number 3. I have a question, and I just have questions on 4, 5, and 6.
All right, so
You want to just take my questions before we do?
Sure.
On item 4, this is the water wastewater lab service. I know that we're doing all our wastewater testing in an outside lab. Have we consolidated to have it all done in one place, or are we still using 2 different labs?
We use one as a backup because they have to pick up and delivery every day, and we can't be totally dependent on one.
Great. I'm satisfied with that one. And on items 5 and 6, at least both of these are having to do with similar services. I guess in the future I'd like to see some verification that these rates were market or competitive. At least, like I said, with those 2 that were both kind of the same type of service, I could look and say, yeah, they're both in the same range. But when we're renewing these contracts, we need to make sure that we're showing some effort that we have verified that we still have comparative rates. And with those comments made, I'm just still removing number 3. Correction was not made on those minutes.
All right. So we're adopting 1, 2, 4, 5, and 6. Is that correct, Mrs. Turner?
That's my motion.
Yeah,
motion to approve.
And Mayor, open it up to the public.
Yes. Public comment, and this would be on 1, 2, 4, 5, and 6. Seeing no comment, I'll close public comment and having a motion, and I believe a second. Did I not have? I'll call voice vote. All in favor?
Aye.
Opposed? It passes 5-0. Now, Mrs. Turner, you have the floor on 3.
On number 3, I just ask that be brought back once the correction's made. The next meeting. Thank you.
Well, that's certainly agreeable. Is there any further action needed than that, Mrs. Bach?
No, sir.
So we're going to come back around on the consent agenda next meeting?
I will bring it back.
Yeah.
Okay.
All right, that will move us to public hearings. 4B, there being nothing under A. 4B1 is a resolution of the City Council of Vero Beach, Florida, directing the city staff to develop a detailed process to hold a referendum of the city's named retail electric customers regarding the establishment of a utility authority to operate the business of the city electric utility, providing for an effective date requested by Attorney Chef Wright. Chef, you should probably come forward and we'll move forward. Do you want to give us a preliminary comment?
Yes, sir. Thank you. As we all know, the town has sued the city, alleging that we violated Section 366.04 sub 7 Florida statutes, which was enacted in 2008 and which would have required certain cities meeting defined criteria in the statute to hold referenda amongst their named retail electric customers. And if the referenda passed as provided in the statute, then they would, then the subject cities would be required to propose a charter for a utility authority to operate the business of each subject electric utility. In 2008, and this is actually well documented in the minutes of council meetings during that time period, the city evaluated the criteria as articulated in the statute and determined that the statute does not apply to the city because we don't meet the number of customers criterion as the customer's term was defined in the statute. And additionally, the city served outside its home county, which was another criterion in the statute as of September 30th, 2007, which was the date specified in the statute. Fast forward to today, the town has sued the city on this, and the county actually raised an item like this in their declaratory statement petition to the Florida Public Service Commission, saying we need to comply with the statute. We don't agree. Nonetheless, to address the concerns that have been articulated by our customers, including the town and including the county, staff proposed that we have a referendum that could be held as closely as possible to the provisions in the statute. We engaged Mr. Ron Lebasky, who has for 26 years been the general counsel for the Florida State Association of Supervisors of Elections, to consult with us on this. And we've communicated with Mrs. Swan, the supervisor. She can't run the election because she can only run elections that are of registered voters and that involve whole precincts. This has a whole different electorate. This has the electorate of the named retail electric customers of the City of Vero Beach electric system. The bottom line is that we recommend doing this, and we also, and the related item on the agenda, to move forward to establish a utility authority, to at least set up the framework in an ordinance, or an ordinance that might be just an ordinance, or an ordinance that might provide for a charter amendment, whatever it would be, to set up the utility authority with geographic representation to operate the business of the city's electric system. We propose this as a matter of good faith to address concerns articulated by our customers.
Questions of City Council?
Once again, I think this is far more complicated, than it needs to be. I mean, the issue with the county and Indian River Shores is that they wanted a representative, independent utility authority. Whether we establish that by this overly complicated referendum and next, or whether the council right here says, hey, we agree to establish an independent utility authority, and we can do that simply with an ordinance. But to go through these hijinks is ridiculous. And I realize you're saying that this is what the lawsuit was. But let's get to the point, to the gist of what they really want is representative utility authority. I mean, our utility commission now has no county Vero Beach customers on it. None. No representative. So is this council willing to go with a representative utility authority? I think that's the question. And if we are, then let's move forward to get, a document drafted, and we can easily do this, on an ordinance basis. And we're showing good faith to the county and Indian River Shores that, yes, we will go forward.
But if we do it as an ordinance, then another council could simply undo it.
That could be done in any case.
The other
Mr. Wright,
issue,
there was an interesting discussion yesterday at the Utilities Commission about this. It was brought up why we were doing this, and I think you commented about it being an element of the lawsuit. Wasn't that correct?
Yes, sir.
In other words, we're satisfying.
This is a gesture of good faith to our customers and to address the claims in the lawsuit. If the town really only wanted a utility authority, they could have left the referendum count out of their complaint. If the county only cared about that, they could have left the referendum element, question, declaratory request out of their petition to the PSC. They've sued us over these items, specifically the referendum item.
That the city didn't comply, that the city essentially modified their records. It was what the case is. Once again, you have to get back to what's the want, what's the desire, and that's a utility authority.
And Councilmember, I don't disagree with you. Their complaint does not match what you're saying. Their complaint says they want the court to order us to hold the referendum.
I would make the very brief comment that we're not committing to a referendum. We're committing to a process to hold a referendum in good faith. So it would come forward to us at a further date if there was a need for it, a legal need for it. Right now, there's a legal need for it.
Yeah, and we're actually, the recommendations considered together are for two processes: one to develop the referendum process, and the other to develop the utility authority process. Maybe we will get lucky, and the town will see what we are doing. Hopefully, in my view, after you adopt these resolutions, but that's your call. Hopefully, they'll see what we're doing, and they'll say, "Gee, we will amend the referendum count out of our complaint."
No, because by having this referendum and agreeing to that, the city is saying that no, we are opposing a representative utility authority. And the only way that we will do this is if the court requires us and that we have the results of this referendum.
I don't think we're saying that, but I certainly don't feel that way. But I think there's two elements, and we're trying to satisfy two elements of a legal suit. Is that not correct?
The second item says let's move forward to set up a utility authority in collaboration with the county and the town.
They're not connected, are they? I mean, they're connected in logic, but they're not connected. Let me put it to you a different way.
They're connected historically and sort of legally, but they're not inherently necessarily connected.
So we could go forward with one, we could go forward with both, or only the second, depending upon circumstances at the time.
I would say
Yes,
at least
sir.
wait on the first until we know if the case from Indian River Shores is their lawsuit will be amended. I mean, right now you're responding to what it currently issues, and we know that when the suit gets filed, or should it get filed after mediation, that it certainly may be amended. And I think you're certainly expending funds right now unnecessarily on a solution that I don't believe it's a solution.
Well, at the mediation meeting, the one with the public officials, we specifically said we would consider this, and we also said we didn't really have subject to council approval, have a problem with an authority. So, I would tell you that if on the 17th, if the Indian River Shores folks say that they remove this as an issue from their lawsuit, then we don't need to do this. But I think we do if they don't.
And staff would recommend that you adopt the resolutions, but we can stand down and not spend any money on the referendum process, at least till we see what the town does when they reinitiate the lawsuit.
You stated it better than I did.
I make a motion that we table this until we have more information.
Is there a second? Seeing no second, it fails. We need public comment at this point.
Mark Mucher, 617 Indian Lilac Road in the city for almost 30 years. I'll give you the short version of what I told the Utility Commission yesterday, and that's that this seems to me that the timing of this, at least, is the biggest waste of time and money that I've seen in a long time. I agree entirely with what Pilar said, so I don't want to repeat all that, but everybody believes we're going to a lawsuit. If the lawsuit includes this, which it does now, but they may amend it out, what they're really interested in is lower FP&L rates and a sale to FP&L. This is more a diversion than anything else, and why we're spending even hundreds, if not thousands or 10,000s of dollars even up to this point, is just beyond me. So it's too late now, but I would suggest that it's not too late, that somebody second Pilar's request to table. Thank you.
Mr. Whittle, please.
Herb Whittle, 19 Park Avenue. I'm chairman of the Utility Commission for the city. We discussed this at our meeting yesterday, and we came up with a conclusion that the referendum needs to be worked out and you could work on it because it's going to be some time before it ever gets to the people. But the resolution that the people are going to be voting on needs to be written up and published well before the referendum is put out. I don't see any thing that will help by delaying it. We need to start working on it, and then if it turns out we don't need to do it, we can just scrap it. But I think we should start to work on it now because we got supposedly till November to get it done, and nothing gets done quickly, especially when you got to write something up that's favorable to everybody. So we passed that kind of a resolution at our meeting yesterday. Thank you.
Thanks for your comment. Further public comment? I don't see any. Mr. Wright?
I like the idea that I think is kind of a middle-of-the-road thing, which is don't spend any more money on the referendum until we see what the town does over the next few weeks. I would call your attention to the fact that in the resolution it does direct staff to be back here by the first agenda of March 2015. If you're going to direct us to stand down on spending money on the referendum proposal, we would ask for some relief from that date. But other than that, that's our recommendation.
Mr. Wright, it's my understanding that it is the Indian River Shores lawsuits that's the driver of this expenditure and this action in their lawsuit.
I think it's more than that, Vice Mayor. Our customers have said they want a referendum. Our customers have said they want a utility authority. Let's move forward.
And when you first explained this, I was listening to your language. You said something about a charter. If we do any modifications of the charter, then it's got to go to the vote for the Vero Beach voters.
Yes, sir.
Okay,
yeah,
so really we're talking.
There are different options for how you might set up a utility authority. One is just by ordinance. Another is by a charter amendment, which would be under, embedded within an ordinance that would require a vote. That's a decision for y'all. Just as as your utility lawyer, this seems important enough to me that you might want folks to vote on it, but that's your decision. You could also do it by an interlocal agreement with the county and the town and the city. That poses a host of other issues that could require other steps to be taken. I'm not advocating for that at all. I have verified that is a viable option, but it does pose other issues as to who would then own the assets. Would the city still own the assets? Would the city still be on the hook for the debt? Would the city per se still be on the hook for the FMPA contracts and so on? Or would those transfer to the utility authority?
Right.
If it transfers to the utility authority, you've got to go get the statute changed so the utility authority can become a member of FMPA. But that's all doable. They're just different options. I mentioned the charter amendment as a legal structural option for your consideration. That's all.
All right. Mr. Moocher is behind you. He would like to comment again.
Mark Moocher again. Yes, I'd like to take exception with something that my new good friend, Chef Wright, just said, and that is that the customers want a referendum and they want a utility authority. I would argue that the customers have never said that they want a referendum. As a matter of fact, this is one of the first times the subject of a referendum has ever come up. Secondly, they certainly haven't said that they want a utility authority because as close to this as I am, I don't know what a utility authority is or what it would do for us. I mean, I know basically what it is, but as he said, there are all kinds of different forms. I don't see how it's going to do anything except assuage some people politically, perhaps, but I don't see how it's going to affect rates. It may or may not affect the decision-making process. It's not really what the Shores wanted. They just threw it in there as an irritation. And it's not something we have to deal with today. And I agree that we shouldn't spend any more money, but I'm upset about the money we've already spent on it. I don't know if that was done with direction from council or not. I don't recall direction from council to spend thousands of dollars to lay this out. Maybe it was, and maybe I missed it, but that's my concern. Thank you.
Thanks for your comment. Is there any further public comment? All right, seeing none, public comment is closed. Mr. Wright.
I didn't have anything else, Mr. Mayor, but I'm happy to answer any further questions.
Well, are there questions from council or a motion on this issue?
My understanding is we're just passing a resolution. We're not really directing staff to do work.
I believe that's correct, is it not, Jim?
You are authorizing us to do work if it's necessary to do, is what you're doing.
If it's necessary.
If it's necessary. And I think we're taking the message from the council. We'll stand down on the referendum issue and will not approach that. Apparently, some people know what Indian River Shores is going to do and possibly could talk them into doing that. And then after the 17th, we won't have to worry about that element, so it'll go away. I think we still, in good faith, do need to talk about a utility authority and look at options for the council to consider. And what you do it, as Mr. Wright said, there are multiple options and there are concepts that you can intermingle. We have like 8 or 10 of them in the state of Florida right now.
Six.
And so we would be able to bring that back to you for consideration. But if the element of the referendum goes away in the lawsuit, but as long as it's there, when we hire a litigator, folks, he's going to be fighting that element because that is an element in that litigation. So, but we will stand down on that. Only thing we were asking is that this gives us the ability that if we have to pull that back up after the 17th or when lawsuits begins, and we will not do anything until a lawsuit begins.
Will you be coming back to council before you start expending money on that?
We can do that.
Well, for clarification, I think you're going to need to amend, or if you adopt this, in section 2, 3, and 4, it says directs staff. Perhaps we should change that to authorizes staff.
Yes.
In each of those sections,
yes.
Jeff. And also, by adoption of this is something that can be offered at mediation in resolving the dispute. And I think that's one of the purposes by bringing this forward is to be able to be authorized to be able to offer this.
Well, this council has commented that we need to bring something to mediation several times, and this brings that. And whether it's meant to be an irritation or not, I don't think it's a joke, and I don't think we should treat it as such. And I think that we need to be as prepared as possible, and this allows us to do that. I'd rather be over-prepared than under-prepared. And so I make a motion that we adopt it with the amended changes.
Second.
Okay, there's a motion and a second. Further comment?
Yes. I just wanted to, as we move forward with this, we'll have a budget established. I know that we've expended over $40,000 a month in legal expenses, and I assume much of this is being included in this referendum.
Yes, ma'am. We do have allocated budgeted amount in the electric department's budget for legal services. So we do have a line item in there for legal services.
Granted, but I think we need, if we move forward with these expenses, that we need to have an estimate presented to council as well before we embark on those.
Okay.
All right, I have a motion and a second. I'll call the motion. It's a roll call. Mrs. Bach?
Mr. Old?
Yes.
Ms. Graves?
Yes.
Mrs. Turner?
No.
Mr. Kramer?
Yes.
Mayor Winger?
Yes.
Passes 4-1.
All right, that moves us to the second item, which is 4B2, a resolution of the City Council of the City of Vero Beach, Florida, directing the city staff to develop a proposed ordinance in collaboration with city electric customers, including Indian River County and the town of Indian River Shores, for the establishment of a utility authority to operate the business of the city electric utility, providing an effective date requested by Attorney Chef Wright. And your comment, Mr. Wright.
I think we pretty much covered everything I had to say about the utility authority resolution in the previous discussion. They kind of blended together.
Do you want a public comment on this? Is there public comment on this? All right, seeing now close public comment. Council comment, please.
I just have a question. If we are going to look at setting up a utility authority, is this going to be a true independent utility authority? Or are we going to still require that there be a certain transfer to the city government included in the operation of the utility authority?
Those
My
are all.
question for council.
Sorry.
I'll just give you on the top of my head. I think there would be numerous, if not hundreds, of policy decisions that have to be cobbled out. I don't have any predisposition except that for myself, I think it would be good to have representation of all our utility customers. But beyond that, I have no preconceived.
So you would be willing to have an authority that may change, may add, or may decrease the amount of transfer that the city of Vero Beach receives from the electric utility?
I would say the same thing that I said. I believe there has to be, in some form or another, a return to the owners of the utility, an earning on the capital invested of approximately $120 million. But how that would be done and the amount of it and all the rest of it, I think would be for dialogue. So I can't answer your question better than that. I do not believe that entities, no matter who they're owned by, should be asked to operate either in the red or with no return on capital. I don't see how you further the existence of the entity that way. But, I don't think we can judge that at this point.
I think it's quite simple. I mean, if they want to get rid of the transfer to the general fund, buy it. Be an independent utility authority, buy the utility, and own it. I mean, simply. I mean, Vero Beach gets paid for the utility. The utility authority owns it. They can do whatever they'd like with the returns.
That's the kind of dialogue. I think that's quite useful, and thank you. That's the kind of dialogue I think you have to go through, and it's a long dialogue.
It will be a very complicated authority to set up. There's no question. There's hundreds of things to think about. Yeah.
And Ms. Graves, do you feel the city deserves a guaranteed return?
I think we're going to have to take a look at how this forms. I mean, if it's still our asset and they haven't bought it and they're just running it, then where would the return go? But if they do purchase it, then it's no longer ours to get a return on. This is so complicated. If you look at all the different documents we received on just the election of it, I mean, there is so much to work out.
I feel very strongly that we do deserve a return. There's no question, in my mind.
Although that the electric utility is really owned by the ratepayers. They're the ones who paid for the capital, made the investments. They're paying the debt.
The city deserves a return.
The city deserves a return.
Yeah.
But there's other ways to structure it. It doesn't have to be just the city that gets a return. I've seen one of them is at Lakeland, where the utility authority, some of the members get returns as well, like the actual customers.
I know co-op members do. I'm not 100% sure how Lakeland handles that. They may do capital
so
returns.
There's other
co-ops
ways.
do. I don't know.
There's other ways. I mean, there's lots of ways to structure it, and that's a conversation we can continue to have, but also have in conjunction with Indian River Shores and the county,
and also with the commissions. I mean, it's lots of advice is needed on this.
Great.
With that, is there a motion?
Do we need to modify anything?
Yeah, this one has the same, in Section 2, it talks about directs city staff. Again, you may want to just authorize. And again, I think this is something that Chef would like to be able to propose at mediation, that something we're willing to work on.
Motion to approve as amended by our attorney.
Second.
All right, I'll call the motion. Mrs. Bach, roll call, please.
Mr. Old?
Yes.
Ms. Graves?
Yes.
Mrs. Turner?
No.
Mr. Kramer?
Yes.
Mayor Winger?
Yes.
Passes 4-1.
Do we have anything further for Mr. Wright so he may go back to Tallahassee? Thank you for your attendance today. I guess we're going to have the pleasure of seeing you again this week.
Yes, sir. Thank you very much. I'm glad.
Thank you for all your effort.
Do we need a break?
Thank you very much.
Yes, I think that's an excellent suggestion. Is 10 minutes enough to 11 o'clock?
Yeah.
Okay, we will take a break to 11 o'clock, please. Right, it's 11 o'clock. We'll reconvene. We will move on to item 5, ordinance and resolutions for first reading by title, with future public hearing required. This first one will have a future public hearing on January 6, 2015. It's 5A. I'll read it as follows. An ordinance of the City of Vero Beach, Florida, amending Section 2-301, subsection 2-302, parentheses C, and Section 2-303 of the Code of the City of Vero Beach, Florida, relating to Code Enforcement Board hearings, hearing notices, and interpretations of code provisions, providing for conflict and severability, providing for codification, providing for an effective date requested by the city attorney. So, Mr. City Attorney?
This does amend the code enforcement ordinance. The code board will be taking a look at it next week. It basically, the main gist of it is we wanted to clarify the authority and how the code is interpreted. Obviously, this arises out of the short-term rental issue, where the appellate court seemed a bit confused about how to interpret who the authorized body is or person is to interpret the code. So we're making some changes to hopefully clarify that, and quite frankly, we're still talking with outside counsel, and we may do some other minor changes yet. I haven't gotten a full report back from her. But it's to clarify if, in fact, we have another appeal in the future of who's interpreting the code, and it makes clear that the code board just applies the code as interpreted and goes from there as far as whether or not a violation exists.
The comment I would make on page 11 of 13.4, it says that the board shall be bound by the interpretations and decisions of any duty authorized city official or city board concerning the code provisions. And as I read through this, and I could cite other places, but what I'm concerned with is the duly authorized authority, I believe, is the planning and zoning officer.
Well, not on everything. It's different authorities throughout the code. Matters having to do with drainage is the city engineer. Matters having to do with the building code is the building official. And then there's appeal processes for those determinations, such as, of course, the planning and development director appeals go to the planning and zoning board. Building official appeals go to the board of building appeals, I believe it's called, which meets about once every 5 years. And so on. So there are different authorities throughout. And one of the things we've talked about, and what we'll probably do at the end of the section, is we'll add a definition for the authorized city authority. We're going to actually spell it out and make it more clear of who that is.
I certainly think that's needed. Because I agree with
Yeah, because when I read this last night, and I read city board, and I kept reading that the city board was the code enforcement board. That's just the way I read it, rightly or wrongly. And most of the time it's talking about the Planning and Zoning Commission, or it's talking about Mr. McGarry in his function. I mean, that's most of the time those are the right people, but when I read it, I'm just concerned that it could be construed that the code enforcement.
Right, and that's one thing that I've been told the appellate court struggled with, and that's why the problem is if you don't read it in total, you don't. Apparently, they weren't able to understand that we were not talking about the code board.
Does it need, under the whereases, which I guess are not really completely part of the rhetoric, but the legal rhetoric, does it need another whereas as to what the function of the planning and zoning head is? I mean, the reality is we rely on him most of the time to make the decisions.
I don't really think it needs anything else. We're making clear that we're clarifying the code.
Okay, I guess we should open this for public hearing. Mr. Lambert?
Hi, I'm Dan Lamson, Executive Director of the Indian River Neighborhood Association, and I've got a short statement. The IRNA encourages you to pass this ordinance, and especially looking at this from a lens of short-term rentals, that we encourage you to add as many teeth as you can to that enforcement process to protect our neighborhoods. And just to emphasize, I'd like to say that the IRNA would like to see the short-term rental laws vigorously enforced whenever possible. I mean, you can Google search vacation rentals in Vero Beach, Florida, and there's hundreds and hundreds of results, and that's not anything new. So in the past, it's been hard for enforcement to be done sometimes, and I'd like to see you guys do anything you can to make that easier for the code enforcement board so that they can enforce the code and the spirit that it was written. Thank you.
Further public comment? Mr. Digg.
Thank you, Mr. Mayor. Ken Digg, 1846 21st Avenue. I would ask and encourage all of you to please pass this. Our neighborhood, we certainly need help. We have a number of code issues that get addressed on almost a monthly basis, so any more teeth would be most helpful. Because if you have gone through some of your mainland neighborhoods, they need a lot of help. So please, I would ask all of you to pass this. Thanks.
Further public comment? Seeing none, I'll close public comment. Council comment. Wayne, if you go to page 6 of 8, just for the fun of it, and you look at the two words transient, adjective, transient, noun, I just wonder if that would be strengthened by...
You're on a different resolution, Mayor. That's a second ordinance.
Yeah, I think you're looking at the land use one.
Oh, okay. Yeah, I'm sorry.
I have a lot of questions.
Okay, go ahead, Ms. Turner. You have the floor.
Sorry, let's see what the page is on this. On failure to pay penalty or appeal, this is page 5 of 14, C or E. So the case may be presented to the board even if the civil penalty is subsequently paid prior to the board hearing and the notice of hearing so state. Is this so that if somebody wants to go ahead and pay their fine and they still want to appeal it?
No.
I don't.
What the code provided before, and actually the code enforcement officers asked for this clarification. If a person doesn't pay by the due date, which is a civil penalty, such as with even if it's a correctable violation and they have corrected it, they have 10 days from the date of the citation to pay it. But also, and that's why it was entered in different sections, and then you also have the scenario where someone doesn't correct by the date given for correction on the citation, and the officer hasn't given more time or they haven't asked for more time to correct either. The way the code works is if they don't meet those deadlines, the city then is entitled to the enforcement costs. And the officers wanted it clarified that they could still take it to the board because only the board can impose the enforcement costs. So that's why we've added that language to make it more clear for them.
Further questions?
Not at this time. Go ahead.
Other council comments?
I just have one comment. I know we're making an awful lot of changes, but I'm really concerned about putting language in there that could be interpreted as though we're amending or changing the current ordinance that's on the books.
Now, this is strictly code enforcement. This has nothing to do with the zoning.
Okay. Well, my point being is that I don't want to see language in there that can be interpreted as though we've changed our underlying zoning ordinance that gives us the right to do this.
That'll be your next ordinance.
Okay. Well, we just want to make sure that these things, I know they're kind of
this
related.
is strictly the procedural rules for code enforcement, how cases are brought, how they're resolved. This is for all violations, not any one specialized or specific type violation.
Okay. You found another one? Go ahead.
I did have another question. On page 8 of 13, this is on the hearing record. It said that the violator should be responsible for ensuring a verbatim record of the hearing is made at the violator's expense. by a certified Florida court reporter should the violator intend to appeal any adverse decision of the board.
Hey.
I'm sorry. I mean, I think that's imposing a great deal
That's
on
state
somebody
law.
who may be bringing.
It's state law. I mean, it's in Chapter 162. If they want a record so they can appeal, they have to pay for it. They have to provide their court reporter. And we specified so it's clear to a violator, they can't just have their friend come in and take notes. It has to be someone that's certified and it can create the record. Now, that doesn't mean they can't still appeal if they don't have a record.
That's why I find that,
If they want a record. But the problem is then it hampers the appellate court. The appellate court can only look at the cold paper of what was filed in the code enforcement records. And there's no, they read the minutes. They could get a certified copy of the minutes, but that'd be about it. What we were trying to do is take out we did have provision before, and Tammy just doesn't have the staff to be transcribing minutes into verbatim minutes, even if they pay for it. And it's not required. Like I said, in 162, it says it's up to the violator. If they think they might want to appeal, just like if the city thinks they might want to appeal something, we'd have to provide a court reporter to have that record if we wanted that full record to go to the appellate court. I mean, it's not required, but it's their responsibility if they want a record.
Okay, because when I first read it, I thought that was required, and I thought,
No.
before you even go, how do you know you're going to want to appeal? And
No, it just makes them responsible for having the record if they want the record.
You have further questions, Mrs. Turner?
I think that's it.
I would make a motion to pass this, but with a specific change in it that would make very clear who is the authority in each instance, so that the word board or so on can't be ambiguously read.
Right, we're going to work.
That's my motion.
We're going to add a section to address that.
Is there a second?
Second. Move it for a public hearing on the 6th, Mr. Mayor?
Yes, and added to what I said.
With that addition, second.
Okay.
Motion.
Further comment? I'll call the motion then, Mrs. Vach.
Mr. Roll?
Yes.
Ms. Graves?
Yes.
Mrs. Turner?
Yes.
Mr. Kramer?
Yes.
Mayor Weir?
Yes. All right, that gets us to 5B. An ordinance of the City of Vero Beach, Florida, amending Chapter 60, General Provisions and Appendix Definitions of Part 3, Land Development Regulations in the Code of the City of Vero Beach in order to provide clarification and updating of certain texts and definitions, providing for conflict and severability, providing for codification, providing for an effective date requested by Planning and Development Director. And this is for future hearing, the first hearing on January 6th.
Thank you, Mayor. For the record, I'm Tim McGarry, the Director of Planning and Development for the city. The city attorney and I have prepared this draft ordinance, which is intended principally to clarify existing regulations prohibiting vacation rentals in our residential zoning districts of the city. Just as a cautionary note, the ordinance amends the land development regulations, and that requires it to go before the Planning and Zoning Board. So today you're having a first reading, which is a little out of place, but that's fine. We're scheduling a hearing on December 18th for the Planning and Zoning Board, and that should still put you on track for coming back on January 6th. But therefore, obviously, there may be some more changes done to this ordinance. We may have some tonight or this afternoon, today, and we're outside counsel, so there may be some other changes before you see it. So I just want you to be aware of that. The ordinance itself is not intended; it does not establish new regulations, but only codifies the city's historical administration enforcement of the short-term rental ban. And again, this is a balancing act, and we tried our best, and we still be listening to more input on this, to how to balance that so we're not changing the regulations, but trying to follow basically what our official opinion was rendered a couple years ago on this very issue. Specifically, the ordinance provides definitions of terms such as transit, both the verb and the adjective, transit occupancy, and a guest, in terms which are applied in combination with the guest house and transit quarters use. We also, the definition of guest and transit quarters has been revised to clean up a Scribner's error, forgetting the and in there, and some ambiguity in its interpretation. Other changes have been included to codify the common statutory law that applies to zoning, that where a use is not listed, it's prohibited in that district, so we have that in there. We also looked at the definitions of single-family residential structures, duplexes, and multifamily residential structures. They've been revised to clarify it includes the use of the term, not just the structure. That's been in there forever, and it's driven Wayne and I nuts for as long as I've been here. So we figured to take care of that be just another impediment if we get into a challenge on anything. Lastly, we've made some changes to various definitions to clean up and update language and revise the administration of the zoning map and amendments. One mistake has been brought up, and I'm sure there may be some more. It's been brought up, has to do on page 3 of the draft ordinance. On the last sentence under section 60.06B, last sentence.
Doesn't make any sense.
Well, it should be from first consulting to planning, so it's missing a word. And we've had, this is about our 6th reiteration of this, and we didn't catch it. So we'll be adding that. But there, as I explained to you, there'll probably be some other changes done to the ordinance. So I'm open for any questions you may have.
I think Mr. Kramer had an excellent point a minute ago.
Well, I think my concern has been echoed by several people, that I just want to make sure that we don't have language in there that could be misinterpreted or taken that we're rewriting the laws that are on the books now that gives us the grandfathering ability.
Yes, and we agree, and that's why we've been trying. We closely followed my opinion letter a couple of years ago that I wrote on this thing, that's how it's been interpreted and applied in the city. Certainly, we felt we had a good enough grounds in that ordinance, even go by a common dictionary definition about short-term and transit was there. But this does clarify that. And we don't believe that goes beyond what was intended in the ordinance. So therefore, it's a fine ground. We're trying to do what's right. And as I said, we're still open to some further recommendations.
Well, just to build on Mr. Kramer's point, if you were to take the word amend or amendment and use some other word as you go through here, I mean, as soon as you put the word amend, and you've got it in here more than once.
Well, the problem is you are amending the ordinance. So, I mean...
You're clarifying the ordinance.
Yeah, clarifying, but you're amending the ordinance. So you're amending the actual language. But, I mean, maybe we can fine-tune some of the language in the whereases to do that. But, I mean, we're...
Yeah, and the amendments, really, the key section is the definition of guest house and transient quarters. That is what equates to vacation rentals that's in the statute. We're not changing that other than, like Tim said, it was in the ordinance adopting it, but somehow municipal code missed and didn't put the word "and" in the guest house and transient quarters, and its clarification of rooms really means bedrooms. I don't have any problems with those. The keys are that the court, again, the feedback I got was the court struggled with, well, how do we define this? And I've always been a proponent of, well, you whip out the dictionary, but apparently the court didn't have one. And therefore, we actually took a lot of language right out of the statutes having to do with these short-term rentals and used it for like the transient occupancy, guest, what have you. And those you have to refer to now when you're interpreting the guest house and transient quarters. That's the whole key, to give you something to refer to be able to understand what is guest house and transient quarters. So it's right there. And like Tim said, there may very well be some further tweaking when we bring this back to you in January. But we think we're pretty good ground right now with just adding some definitions, because it's still the same thing. It's still the same concept. If it's not listed in the zoning district, it's not a permitted use. We have zoning districts that allow guest house and transient quarters. And we're just trying to clarify how you interpret that term. And it's basically the same thing as any other short-term transient type use.
That was going to be my question, where we got these definitions
Yeah,
from.
we stole a lot from the statutes,
Okay.
trying to make it easier if it's ever challenged again for a court to understand this is what this is isolated.
And I
what
wanted
we're
to
talking
follow
about.
what we gave on my official interpretation.
Exactly.
Because so we didn't want to deviate from that, because that would raise questions too.
Taking that point, again, on page 6 of 8, you have transient, adjective, temporary, lasting for a limited time. But just as a suggestion, why don't you refer to the Florida Code or the one below it, the noun? a guest and transient occupation per Florida code, whatever. You've done that several times.
Well, we don't really need the transient adjective, but
why not refer to Florida code? That's where you're going.
Yeah, well, transient and the court didn't like that idea, and there's actually some court cases out there that say on local zoning codes, no, you can't do that. Well, I don't know. Well, going back to concepts, if you're talking about something in the statutes, the courts will often let you refer to another section of the statutes for an interpretation. Whereas here, it seems like they want to confine you to your own code. You can't go outside the code. So that's why we wanted to add these. But we did get the transient, guest and transient occupancy. That come from statute. The transient occupancy, much of that came from there. So those are the keys. The adjective we don't necessarily have to have there because, again, you could pull out a dictionary and basically get that definition.
And I'll be honest, I was at the hearing. I don't think transit was the problem there. I think it got back to the code enforcement. We'll never know. We never got a written
authority.
Two of the judges seemed to understand that when they asked those questions. Yeah, what is transit? And they, so I think this clarifies it. And
Mr. McGarry, did I understand also, and one of you said that the outside attorney we had was going to take a look at this before it went to planning and zoning? Is that correct?
We've got.
Okay.
Yes, we
just haven't heard back from her yet. We're going to double check.
We're waiting.
A public comment is needed. Seeing no public comment or closed public comment, either council comment or a motion as you see.
Question, please.
Go ahead.
Mr. Cook, do we believe that with the revisions for both of these ordinances that we will be able to enforce short-term rental?
We believe we were able to do it before, but we waited till these other changes. Yes, and I mean, I'm getting the sense of the council. If you want us to enforce this strongly, we will enforce it.
We want to make sure that we're on firm. You certainly don't want to be enforcing it, opening up the city to another lawsuit.
We think this cleans up any other. Go ahead.
Yeah, the only thing I would add is obviously we have no control over whether or not a violator wants to appeal, and may very well.
Yeah.
If it comes up again, we'll do our best to. I think we've given it as our best shot with clarifying and giving a court sufficient things to sink their teeth into to uphold what it is that it's allowed and not allowed in the zoning districts.
Thank you.
Okay. All right. Is there a motion?
So moved to future hearing on January 6th.
Second, just wanted the question then, as far as just cleaning up the code, then that we removed all these zoning districts, or just to reflect what we actually have?
They were left over. So we went to change it.
I figured it was just a cleanup job, but just wanted to make sure.
In fact, in the future, I'm probably going to try to combine all the multifamily in one. It'll save a lot. We've got so many conflicts. People copy things, and so we're going to try to clean it up. I was going to do that all at one time, but I wanted to get this thing through. I knew it was a priority for you all. So,
all right, I'll call the motion. Mrs. Bach.
Mr. Old?
Yes.
Ms. Graves?
Yes.
Mrs. Turner?
Yes.
Mr. Kramer?
Yes.
Mayor Winger?
Yes. Thank you. Before we move on to city clerk's matters, too, on the rental issue, we're on the agenda. I guess Wayne's on the agenda, Wayne and I, but it's primarily Wayne, working on asking the legislative delegation to reconsider the law that's out there. Do you want to more accurately state that, Wayne, than I did?
Y'all should have gotten a copy of the letter that I drafted to our legislators, and what I concentrated on was this very zoning issue. It's as far as regulating duration and number of stays in a year and things like that. Those are all things that are pretty much, it's kind of regulated by state statute. We never really have regulated those things, but what we have regulated and want to continue to regulate and make it clear that we can in other cities and counties is where these type of uses can be. As I think we all firmly believe, they don't belong in single-family residential neighborhoods. They're a business. They're short-term. They're not like a group home that are allowed by state law that we can't prohibit. But those are residences. Those are long-term people that are there. It's a little different when you start forcing motels and hotels into residential districts, and that's what that legislation does. Even though I think we'll be on good ground in our grandfathering, I think it's still worth bringing up to the legislature that still needs to be addressed properly and to stop the interference with local zoning regulations as far as the location of these things.
Any further comment in that area?
Unless someone objects to that, that's what I'll present on Friday.
All right, I guess we've covered that. We'll move us to city clerk's matters. Mrs. Bach.
I have nothing.
City manager's matters.
Yes, I have one item, just continuance of discussion. This is on the parking enforcement on the beach side. Our committee has met again, and we have another meeting scheduled this week in which we have discussed about those issues and concerns. One of the things that came out of that discussion, and this is not really a formal committee, it's really a ad hoc with a lot of businesses represented. We had very good representation from the Chamber, the Oceanside Business Association, as well as a lot of merchants. And we're in the process of changing the 2-hour parking to 3-hour parking on the beach. And they also would like to see the Saturday enforcement. So once we get all of the 3-hour parking signs up, we will start that Saturday enforcement probably within the next couple of weeks.
Are the signs out directing to the guarded beaches? Have those been?
Yes, ma'am. And if you go down 60 right at Beachland and Ocean Drive, you will see their brand new set of signs.
Okay.
I call it sign proliferation, but everybody has their own little thing about it. Also, if you see our signage coming on Beachland as you enter to A1A, it has the signs, even gives the distance to the various beaches north and south. If you go down to 17th, you'll see a sign that says guarded beach to the South Beach area. Obviously, if you go up north, you'll see the beach there, so we didn't bother to put any more signs there. But we have put considerable amount. We're also improving the signage on the free parking area that has no time restriction. For example, across from Hummelson Park, making those signs a little more available for the public to see.
Okay.
I will say that we've gotten very good input from not only the businesses but also the owners. There have been conflicts, as you've heard, and we're trying to wade through those. But I'm going to try to make the decision as best that reflects what I think the great majority wants, and to also make sure that we keep our vitality of our business area down there.
Mr. Connor, were we able to get any more concessions from some of the Ocean Drive business owners about their employee parkings, particularly on the weekends?
No, ma'am, we've been very unsuccessful, although I will say that Mulligan's did. We spotted a location for them in Riverside Park that's removed from where the theater and the museum is, and there for a little while they were having their employees park down there. I don't know how readily it's used, but their employees have also been noticed because some of the merchants have given us car numbers, truck numbers, and we've gone out and made the owners, when contacting of Mulligan's, he immediately understood at least one of the vehicles and who owned it. That employee was very apologetic and all that good stuff, and I don't know where they're parking now, but it's no longer in front of any of those businesses that recognize his vehicle. But when for example, at the Driftwood, which was an individual, that spoke quite loudly, one of the ideas that we passed with him is if his company would go out and rent a van, as an example, or buy a van, and then we would show them a parking area at Riverside or somewhere that the city would own. It'd be no charge. They could use it. Also, the parking garage. The owner of that has been contacted several times. The concern that they have is just unrestricted free flow of parking in there. It outweighs even the liability exposure, but it's one of those that he wants to make sure that if the beach traffic uses the top floor, as an example, that's all they use. And so that would require that we would have someone that would be an attendant at that location.
Yeah.
I have thrown that out and said to the merchants, if somebody wants to have an attendant there, this would be another option And the city, and I have offered on behalf of the city that we would sign a lease like for $1 a year or something, but we would take over the responsibility. But if we're going to have an attendant there, I want somebody responsible for paying for that attendant. So we have thrown that out as an option. That's still being explored or being discussed anyway.
I know, a tough issue, a lot of emotions on both sides of it, and I appreciate you coming up with, I guess, this compromise in the 3-hour. We hope it'll be successful as we go into season.
Yeah, and it was very good because it was really a unanimous decision, and we must have had 12, 15 people in attendance. And again, the Chamber and the Oceanside Business Association have been a real part of that. They have been in attendance at all the meetings.
All right, I have one, just an update. Where are we on the post office where the lease expired and so on? Probably the public could have some interest in where we are.
Yes, the post office was still interested in us pursuing a lease. What I have done is talk to Mr. Eric Menger at the airport to try to come up with an FAA type of lease. As you know, there's a return on that investment. We have hammered out, for example, the post office would like to have 5 years, but they don't want it renewed every year. They want a 5-year lease, and as I pointed out, that means that I start with what I think the value is in the 5th year and have that set in place in the 1st year. They weren't real crazy about that idea, but we needed an appraisal of the property, and said that the way we handle that at the airport in the majority of times is the tenant, the requesting party, pays for that. And so we have made that request to the post office. They said that they would pay for it. We got an estimate for the appraisal of $2,200. The post office said that they would send the money. I don't know if we received it yet or not, but it was going to be coming in the next couple of weeks. Once we receive that payment, we will go out and get an appraiser. We will just run it through the same thing. And again, they understand that there would be no lease except approved by the city council. And so we're going to do that FAA type of evaluation, and the lease would go back. We have made it very clear on several occasions. I've made it very clear that the city is not really interested in being a landlord. The post office is one of those unique situations, but at the same time, we would expect a return on that investment of the property and the least amount of exposure to the cities that we can have.
Thank you. Further questions of the city manager? Mrs. Stern?
Just one question, Mr. O'Connor. I was looking at our FMPA bills for October, the month of October, and under Stanton 2 project, they would billed us $269 per megawatt hour. Have any idea what's going on?
No, I will say that under those bills that we also take the notice with FMPA that we have the right to review and check those numbers for accuracy. There have been mistakes made, but typically they're 30 days. Changes are within that 30-day period after we receive the bill. But
thank you. If you get back to us on what was going on. This is. And for the public, I mean, the going rate, Vero's rate's 120, and I think FPL's is around 96 or something a dollar megawatt. So this is 269.
Well, typically that's because they're doing maintenance on one of their generators. I mean, there's been times where St. Lucie's been up to $500-600. When they're out of maintenance, you still pay the cost, but you don't get any power, which means that your cost per megawatt hour just goes through the roof.
That's why I was just asking the question.
And we do have to pay fixed costs.
You know, it's an excellent question. These are the same invoices I gave you, Jim, in that it looked like they had reversed the energy and monthly fixed costs on the other stand. In other words, there are very good questions about those bills.
Thank you.
We will look into it and get explanation.
Thank you, sir.
Any further questions of the city manager? All right, city attorney, any questions?
I don't have any.
Seeing any no questions, we'll move on to city council matters, old business. And this is really, I've introduced an item, but I'm really, it's not my item in the sense that I just listened to what Vice Mayor Kramer and Councilwoman Graves said, that, you know, as we consider the stormwater utility that needs to be taken to the public. So, we don't need to discuss it today, but I think it's something that should be done. What I put on a sheet of paper only was that, we could have a function January, February, whenever on the mainland, and one on the island at one of the city facilities, and expose to the public what we're talking about without editorial on my part. So
and I certainly think it could be of value, but I guess it's still, to me, a little premature. I mean, I assume we still have a consultant that's preparing the stormwater utility, although I don't know what the budget was for the consultant, or
Bonnie.
We'll go through that. But, obviously what is stormwater utilities going to look at? How much money is to be raised? Will employees be transferred? Oversight of it? I mean, there's so many questions that we need to have before you can think about taking this to the public.
Yeah, well, Ms. Turner, I certainly agree with you, and I just didn't want to let a good idea get dropped, so that's all.
Monty Falls, Director of Public Works. Since the council's directions at the last meeting, we've tried to develop a schedule of what it might look like to get a consultant on board that would be able to talk to us. And I think it would be important if we chose to go forward and hire that consultant, to have him there with us when we did those workshops. So someone that has more experience at developing these than we do, since we've not done one, and hopefully they would have done many in their repertoire. But looking at it, if we started and issued that RFP the first of the year, it looks like we could go through that process and have something back the first meeting in April to the council.
Okay.
If we then, that would give us a chance to take it to the Utility Commission, have them look at it. Cindy and Rob have agreed to work with us on the scope. We're setting up that meeting right now. Jason Nunemaker at Fellsmere and Joe Griffin at Sebastian have responded to my request for information, and they've given me some things they have. Bill Messersmith is reaching out to the Florida Stormwater Association and the Florida League of Cities for sample RFPs. So we're trying to put that information together so that we can have something and a schedule developed with you. And if we get this information, we'll see kind of what the fees look like and bring that back to you to talk about again before we start moving forward.
That's a good answer. Anyone else have any further comment?
I just think that it was really well done. I really commend you on putting this together. It's a great idea. Really, really good.
Thanks, and we hope to have something as soon as we can back for you.
Since it's your idea, Amelia, and yours, Jay, are you happy with everything that was said? I mean, the idea of the... Yeah. Okay.
Absolutely. I think especially if we show people the projects and the benefits, then we can really hear from them what they want. So thank you, Mr. Mayor.
All right, that moves us on to individual council matters, and I have one that touches on the same subject. We have a resolution of the Treasure Coast Regional League of Cities requesting the governor of the state of Florida to task the Department of Economic Opportunity with providing funding to the Florida Department of Transportation to assist all municipalities on the Treasure Coast with matching funds to retrofit FDOT outfalls in any municipalities on the Treasure Coast with modern baffle box technology to help alleviate pollution from entering the Indian River Lagoon. And this is a petition they're asked to be signed. It maybe should be brought back to the next city council meeting, but it probably shouldn't be ignored. I don't know. And I'm probably the only one with a copy in front of me, so that's...
I would certainly suggest you copy all the council members and bring it back in January 6th meeting.
It was public record, but it's just something it was November 22nd. Public record, and I will put it on the agenda for consideration for the next time. I think that's the proper way of handling it. Thank you for your comment on that. Also, we had another one that came in from Patricia Christensen, who is the Treasure Coast Regional League of Cities representative. Well, anyway, they're asking for we prepare for the legislative session in Tallahassee. I would appreciate it if you would forward me your city or town's legislative priorities so I can put a document together for those elected officials that are part of the advocacy team, and other elected officials will be heading to Tallahassee during the legislative session. And obviously we have a one on rental. I mean, we could let staff tell her that if that's satisfactory.
Be fine.
Is that... I'm just responding.
Yeah, I think certainly we could send a copy of the request you have for speaking at the delegation thing, as far as on the short-term rental, that would...
Okay, that would be fine. It's one of the things that we had a pile of mail after Thanksgiving. I'm reading it. The last one I have to read is November 20th, and this is from Florida Department of Economic Opportunity. And without reading it, because it's in legalese, and Anna Richmond, they are accepting our comprehensive plan with lots of words, but I think that was the gist of it. So good job on the comprehensive plan, guys. That's all the comment I have. I spent an awful lot of time out of town, so I didn't do a lot of activities the last couple of weeks. I did want to talk about the Christmas parade here on Ocean Boulevard. It's coming up 6 o'clock this Saturday, and I guess I got a question for the council. Are we going to walk in the parade or have a presence?
Have we been invited?
Saturday.
It's Oceanside Business usually.
Yeah, they never officially invited council. I mean, I'm sure they would
We're not allowed.
like you to be there, but I never got anything in writing or anything from this year.
Invited, so
Crash a parade, that's a new thought.
Well, I don't think they're going to have a problem if we decide to show up.
But I did want to put a pull in for Friday, December 5th, is our boat parade and our Christmas tree lighting ceremony that the city does at Royal Palm Point, and that starts at 5:30.
Okay. Well, I'll check with you and see if there's any interest as far as Saturday, and then I'll let Amelia talk about the Royal Palm Point deal. But in any case, I hope everybody has a happy holiday, because this is our last meeting until January. Thank you.
Amelia?
It's Ms. Turner.
Yeah, Mrs. Turner, I'm sorry.
I did attend the Treasure Coast Regional Planning Council, and they went through their comments on the all aboard draft EIS statement. I've got that draft here. We'll give that to Mrs. Vach to make sure council receives it, as well as I'm sure Mr. Daig would like to. They have submitted those comments, and they are going to request an audience with the Federal Regulatory Administration. And this would be our 4-county Treasure Coast group meeting with the Railroad Administration. So I think that's a great opening. They will also be asking if any revision to the EIS, that they continue with a 75-day comment, and we'll see how successful that can be. But once again, I want to remind everybody, it's not too late. Comments are due. Tomorrow's the deadline, December the 3rd. Check our website for the location. You can email it to John Winkle. It is so important that we have as many people from the community expressing our concerns. And if you need any kind of format for how to express your concerns, they've got not only the city's comments, but the counties. And if Ms. Vach would put the Treasure Coast Regional on our website as well. I appreciate that. And I was going to talk about Royal Palm Point, but I might leave that for Ms. Graves to talk about that on Friday. Saturday, Osceola Heritage Marker will be dedicated. This is at 19th Street and 20th Avenue. This has been a credible project with Anna Brady, with Deborah Day, Vicki Gould, all the people work, Debbie Aber. Anyway, I know I miss a lot of people, but I'm working on trying to preserve our heritage and our history here. I hope to see you out there to appreciate this new marker. And remember, on Saturday evening at the Oceanside Parade.
Okay, so to follow on Ms. Turner, I'm really excited about the Osceola Park neighborhood dedication, because that is my neighborhood, and this has been a huge collaboration for a long time. It's at 10 a.m. There's a walking tour led by Anna Brady where you can walk around the neighborhood and see the different homes from some of our founders who started this community. I also want to thank Ruth Stambridge and the Indian River Historical Society, because they are covering the cost of the marker through some grant money. The Vero Beach Holiday Fest at Royal Palm Point is this Friday at 5:30 p.m. There's going to be games for kids. There's going to be a beer and wine garden. Hamp Elliott and Rhett Palmer will be there. We will be there, right? Yes. Okay. We will be there. And the boat parade is going to be really, it's just so pretty to see the boat parade on the Indian River. I got a chance last week to go to the charter inauguration of the Youth Exchange Excel Club Pathfinders, which is in cooperation with Youth Guidance. And these are young high school students in Indian River County who are getting into a community leadership program, and there are really high standards and a lot of work required of them to participate, and they're going to be working on community projects. So I would just ask that the community embrace them as they work to improve their leadership skills and improve our community. I was really impressed with all of them. So that's it. Thanks.
Mr. Old?
I, too, have been away for a while, but it's nice to come back to all this. One of the things that I got was a list of the legal expenses that we've had over the last number of months, and on the utility thing. And one of the things that I've done has been closing a bank that's been in litigation, and I had actually 19 law firms working for me in about 20 countries, and none of the legal fees were this low. None of them. So this is really good. I mean,
don't encourage.
But the rate that is charged, the rate that he charges is very low, very reasonable, and I think that that's important, and I think it's very good. Anyway.
So I just want to add to wish everybody a very wonderful, happy holiday season and a Merry Christmas, happy and safe Merry Christmas.
Would you like to make a motion to adjourn?
Before you do, remember there's the ARC Trail. The Vero Beach Arc
Friday
Club
night
has the ARC Trail this Saturday. I want to encourage anyone.
It's a busy Saturday.
It is.
After the heritage markers, before the parade, so make the ARC Trail too.
Wear your sneakers Saturday.
All right, with that, we are adjourned.